daughter. In case she dies, that cow will now become for my son. That is what is called the trust restriction that is provided in the Trust Restriction Act. Then we have the Probates Resealing Act that provides for instances in which a will that has been prepared and issued in another country to be resealed within Zambia. So you have those two statutes that impact on the Wills and Administration of Tested Estates Act. Today we'll focus on the law that provides for wills. So any person who is of sound mind and above the age of 18 or above can write a will. Any person of sound mind above the age of 18 can write a will. Obviously, sometimes it can sound a bit strange that an 18-year-old can have property that he is disposing of. But when you look at it from the point of view that you can have perhaps a footballer who is active and is playing and makes a lot of money, by the time they're 18, they might have property worth disposal in a will. So for you to be able to write a will, you should be of sound mind and above of the age of 18 or above. What do we exclude? Land held under customary law cannot be disposed of in a will, or property held by a chieftaincy cannot be disposed of in a will. What are the powers that a testator has? A testator is a person who is drafting a will. He can distribute property to anyone, okay? He can distribute property. For instance, he can say, I'm giving 90% of my property to the church and 10% to my family. I have, in my practice, come across testators who have left property for friends, even female friends they were close to in the past, or children who are probably not even known to the spouse at home. So a testator can distribute property to anyone. A testator can also appoint an executor or an executrix. So an executor is a male, executrix is a female. So a testator can appoint anybody who is aged 21 or above to be an executor or an executrix. The maximum number that can be appointed as executors or executrixes is 4. There are some restrictions that are provided for in Section 3 of the Trust Restriction Act. Like I have given the example, you cannot, for instance, provide for a bequeath to this person in case that person does not dies or whatever, I'm giving to another person. The law does not allow that. A testator can also appoint a guardian for their children. The bottom line is that a testator can only dispose of property that they are entitled to at the time of their death. A testator can only dispose of bequeath property that they are entitled to at the point of their death. What are the requirements for a valid will? Number 1, it should be in writing. Number 2, it should be signed. This one is very important. If you want to ignore anything else that I say, please focus on the next 2-3 minutes on what I'll say. So a will should be in writing, should be signed at the foot or the end by the testator. The testator is the person who's writing the will. Or another person can sign at his direction. Okay? Number 1, signed at the foot or the end by the testator, or another person has to sign by the testator. Number 2, the signature must be acknowledged by 2 witnesses who are present at the same time.
You had 6 quarter.
The testator has signed, the 2 witnesses signed at the same time. at the end of the will, and they must sign in the presence of each other and in the presence of the testator. A person may not witness a will if they are of unsound mind.
I even wanted to give you back your
Beneficiary
100
cannot witness a will because he will lose his
this
bequest
money that I
if
have,
he
I wanted to
witnesses
give
the
you
will.
back your 100 kwacha.
Where a testator is not sighted or is not able to read, we use the word illiterate or blind. A person who is
Let him
competent
buy
to
for
make a
30
will,
kwacha.
who has not participated in making the will, shall
advise
read
others
and
to keep
carefully
their mind.
explain to the testator, and afterwards shall declare in writing that the testator appeared to perfectly understand the contents. So in the first part, I am talking about a person who is sighted. He's able to write a will, and to do so, he must sign at the bottom or end of the will, and he must have two witnesses who are both present in the presence of each other and in the presence of the testator. I have now moved on to a testator who's not sighted or who is illiterate. A person who has not participated in drafting the will explain the contents to the testator, and then he will write that the testator appears to perfectly understand its contents. There are other ways in which a will may be attested. That's why I said this is written and unwritten. So I'm now moving on to unwritten. So a member of the defense forces who is in active service, or a member of the security services who is in security operations, or a person who is ill, very ill, or has been physically injured and has a settled hopeless expectation of death and has abandoned all hope of recovery, and who eventually dies of that illness or physical injury, may write a will in the following circumstances. So what we are saying here is that if a person is a member of the defense forces or the security forces and they're in security operations and they're in service, they can prepare a will in the manner that I'll just explain shortly. A person who is very ill or physically injured and has given up on living and dies of that illness or injury can also write a will in the manner that I'll explain just now. So we are talking about perhaps a person who has been involved in a road traffic accident. That is sudden, you can't plan for it. In those circumstances, a will may be prepared in the following manner. Number one, written and unattested if the material provisions and the signature are in the handwriting of the testator. The second part is it can be written whether or not it's in the handwriting of the testator and attested to by one witness. So, for example, in a road traffic accident and the testator tells the person, please, can you please help me? I want all my property to be given to my wife and my children. I don't want any other relative to benefit. And then the witness signs, that is a valid will. It may also be made orally before two witnesses. So this person who is physically injured or is in the security services or who is very ill can call two people and say, please, I didn't write a will. I would like my property to be given to this relative. If there are two witnesses, even if it has been made orally, it is a valid will. So a will providing for, may provide for payment of debt. A will cannot be invalidated by reason only that one of the people who executed the will was incompetent or did not qualify. Okay. So the major factor of a will is distributing assets or property to a beneficiary. Who is a beneficiary? The Act, the Wills and Administration of Tested Estates Act, does not define a beneficiary. But a beneficiary is a person who a testator has named to benefit from his will. So a beneficiary cannot witness a will. If a beneficiary witnesses a will, he loses his gift. Unless it was just a debt. For the debt he can get, but the benefit in the will he will lose. A beneficiary can be admitted to prove due execution of the will despite the fact that he has lost a benefit to his gift in the will. A beneficiary cannot lose his benefit if he merely witnessed a codicil. So let me take a few minutes to explain what a codicil is. A codicil is an amendment, a variation, an alteration of an existing will. So assuming you have a will which is lodged and is being kept, and then you fall into good fortune. You buy other properties, other houses, other cars. Instead of you going to retrieve the will, you simply do an additional document called a codicil, okay? Where you again bequeath property. Now, that codicil has to be executed in the same manner a will is executed. You do not need the original witnesses who executed the will. Any other two witnesses will be valid, but it must be executed in accordance with the rules or tenets that apply to execution of the will, i.e., signed at the bottom or the end by the testator, witnessed by two witnesses, both present at the same time, and signing at the direction of the testator. A beneficiary will not lose his interest if there are two witnesses who witnessed the will. In my practice as an advocate, I have never encouraged a testator to tell the beneficiaries what he has put in the will, okay? This is for many reasons. For example, if in a marital situation, a testator explains to either the wife or the husband that, oh, okay, in my will, I've given half of the property to my mother because I believe that she can take better care of the children. Instantly, that will stress your marriage or your relationship, okay? So I do not encourage testators to tell beneficiaries what is in the will. You simply tell them, I have prepared the will, and the will is with so and so. Whether it's with a lawyer or it's at the High Court, you simply tell them where they will start from. There are times that people are very ill and they tell perhaps a member of the family that I wrote a will. Where is the will? Silence. Who has the will? Silence. You not help yourself. You're not doing yourself justice if you do not tell the testator where the will, the beneficiaries where the will is. In the event that a will is prepared and a testator has not made reasonable provisions for his perhaps wife, husband, or child, okay? A wife, husband, or child may apply to court to vary the will where he feels that the testator did not make a reasonable provision. So this provision is in Section 20 of the Act. It applies to a wife, husband, or child, because in the Act, those are the ones that are defined as a dependent. So in such a situation, the court may order the estate to maintain that person. It may take the form of a lump sum or immediate payment, an annuity, or an interest in property. But one may wonder why you'd have such a situation. It is possible that you can have such a situation where parties are estranged at the time that the will is being written. They may decide to exclude certain people in the family. There's a case of Isaac Tantameni where the testator excluded his daughter from the will. So when the daughter challenged the will, it's a long case which was settled by the Supreme Court, where the daughter attempted to challenge the will. He said that he excluded her from the will because he had been blackmailing him. So there are instances that a testator can exclude members of the family, and he will explain in the will why he has done so. So the person who has been excluded needs to make an application to the court for the will to be varied to include the beneficiary. Now, such an order will only be valid until the spouse remarries, and it will apply to a child until that child attains the age of 18 or death of the dependent. So there are other factors that have to be taken into account. An application should be made to the court within 6 months from the date when the representation was for the testator was taken out. Okay, I've seen some questions. I'm not sure how I can access them, but for now, I'll note them. So I did explain about a codicil. A codicil is a document barring an earlier will. It has to be witnessed in the same way that a will was witnessed. Can a will be revoked? For sure it can. A will can be revoked by codicil or by a later will, expressly stating so. It can also be revoked by a written declaration, which is witnessed like a will. It can also be revoked by burning it, destroying it, or destruction. However, if the destruction is by accident, it can be resuscitated. I'll use the word resuscitated. Where more than one will is found to exist, the latest one will be treated as a valid will. A will that is revoked cannot be revived, can be revived by a subsequent document. But however, a will which has been revoked shall not be revived by revocation of a subsequent will. Let me explain this. A will is revoked by a will which has been written. The fact that the subsequent will is revoked does not automatically resuscitate the will which was revoked. I'll now move on to explain what an executor is. Okay, an executor or executrix. I said an executor is male, executrix is female. Is a person who has been appointed to administer the estate and distribute the estate. This may be expressly in the will or impliedly appointed under a will. So impliedly would be my elder sister who lives in blah, blah, blah. Or expressly, I appoint so-and-so to be the executor or executrix. An executor must be above the age of 21 and should be of sound mind. Once the executor is appointed, he may renounce the appointment. The maximum number of executors that can exist is 4. What are the duties of an executor? This one, there is actually settled law that has stated the role of the executor is to pay debts and funeral expenses, distribute the estate, produce an an inventory, and render an account of the estate. So what it is that it's not in the executor's place to start growing the estate, to grow the estate so that there's a lot of money at the end to distribute. His role is merely to distribute the estate, depending, of course, on the instructions of the testator. If the testator says, I want the executor to be paying the school fees until the youngest child is so-and-so, so be it. The expenses of the estate or of the executor are borne by the estate. These will be good faith payments and not extravagant expenses. For example, if as executor you say, I'm chartering a plane to go and check if there are properties that were left on the copper belt, for example. Depending on the circumstances, that would be held to be extravagant. Okay. Can the appointment of an executor be revoked? Yes, it can. If the proceedings from which the grant was made is found to be defective, it can be revoked. If the grant was obtained fraudulently, maybe the will was a forgery, it can be revoked. or if there was untrue information at the point of obtaining the probate, or if the grant has become useless or inoperative. For example, the properties have been distributed and there's nothing else to distribute. Or if the person to whom the grant was made has omitted to furnish an account of his administration. So the way it works is like this. The deceased appoints Mr. X as executor. Mr. X, for a full year, he's running the estate, driving vehicles of the deceased, and he does not render an account. The beneficiaries can make an application to court to revoke his appointment because he has failed to account for the estate. What happens to disputes? A party can apply to court to determine whether a will is valid or whether the deceased was entitled to property at the time of his death. A party can apply to court for an order to sell a property or to appoint a guardian in place of a guardian who has acted improperly. Remember, I did say earlier that a testator can appoint a guardian for his children. So if a guardian has acted inappropriately, another guardian may be appointed in place of the guardian. Intermeddling. This is quite common. You find that perhaps people who are related to a person who has died will start driving vehicles, will start going to the office of the deceased, or even start collecting rentals. That is what we call intermeddling in the estate. Only a person who is appointed by the court has power, and mandate from the court has got power to deal with the estate of a deceased person. Another offense that is common is depriving a beneficiary of his benefit. This is another offense. Another way could be interfering with use by the beneficiary. How would somebody do this? Harassing the beneficiary. You have to move from this house. This house, we want to put it on rent so that other people can benefit. You should not interfere with the benefit once it has been bequeathed in the will. The penalty for what I've just talked about is 750 penalty units. I didn't calculate this, but to find the kwacha equivalent, you multiply by 13 way. You multiply the 750 by 13 way. Or imprisonment for a term of 2 years, or both. What is the role of the High Court in wills and administration of tested estates? Number one, disputes are determined by the High Court. So when you have a dispute relating to a will, they are determined by the High Court. Number two, custody of wills may be done by the High Court. I've said may be because it's not mandatory for you to keep your will at the High Court, but it's the most secure place and it's very cheap. I'm quite certain that if you kept your will at the bank, it will not be for free. You'll be making a monthly payment. But if you keep your will at the High Court, you pay a one-off amount. I think at my last check, it should have been around 22 kwacha until in an instance when you die. The High Court also grants probate, which is the power for the administrator, the document that authorizes the administrator to start the executor or executrix to start acting. So wills may be deposited at the High Court, and storage of a will is very important. This is, I'll put it this way. In the event that a beneficiary discovers that you have left them out or you have given them very little, they may get frustrated and unhappy, and it will affect your relationship with them. It may strain your relationship. In an extreme situation, if, for instance, you say that I've given all my property to my son, okay, a 23-year-old who has failed his school and has failed to do anything and is just waiting for you to die. It may be a big temptation on his part to cause your death so that he may benefit. So storage of a will is very important. And I would encourage those who would like to do wills to prepare the will with perhaps the services of a lawyer and store the will at the High Court. I can guarantee you 101% that there is no possibility that the will can be opened or interfered with if it is at the High Court. But if you keep it at home, there's a possibility that somebody may be tempted to open it and reseal it. Or you can keep it with a lawyer, but with the way life is, the lawyer can die, the law firm can close, the law firm can burn. So my best bet would be for you to keep the will at the High Court. Foreign wills may be registered in Zambia through a process we call resealing. I have tried to take you through a flight of the wills and administration of tested estates. I'll step aside for my colleague to come and talk about inheritance. Then we can come and discuss whatever questions you may have. Thank you.
Good afternoon, everyone. Thank you for allowing me to share this presentation with you this afternoon. My colleague has just spoken about wills, and she mentioned that some people don't make wills because they are afraid to die. I should add that some people actually don't make wills because they fear to be witchcraft. So my presentation is going to be on what happens to the estate when a person who dies has not made a will, which is what we call intestate succession. My names are Chuma Himonga. I'm a researcher, basically lecturer, and a researcher on the family law, including succession. So much of my work in my research has focused on this topic, particularly intestate succession. Now, the laws are made to regulate the conduct of people in their day-to-day lives. And laws also exist to help people resolve their disputes when these arise from their interactions with each other in various facets of their lives. But you'll find that there are cases when the law is not actually effectively implemented in practice because of some challenges, either in the gaps in the law or just the way that people implement the law in question, that is legislation. In the area of intestate succession, instead of using the law that is, or the legislation that is enacted to regulate intestate succession, I have found out from my research that people use customary laws of the deceased person or the customary law of the deceased person to regulate their property, or they resort to what has come to be known in Zambia and Africa generally to what is called property grabbing. And this is a disorderly way in which interested members to the estate just pounce on the property of the deceased person without following any rules and help themselves to the property. In some cases, we also find that the officials who administer this law of intestate succession do not actually apply it correctly. So because of these three practices of the way that people apply the law of succession in practice, my presentation will not just touch on the theory of the law as it is in the legislation, but I will touch on some of the challenges that that people experience, or the gaps that have been experienced in administering or distributing the intestate estate. Now, my presentation is going to focus, as you can see from the screen, on the administration and distribution of the estate under the Intestate Succession Act, which is the main act that provides for the distribution of intestate succession estates. And this is chapter 59 of the laws of Zambia. The totality of my outline in my presentation is as follows. The definition of key terms, the purpose of law of succession and inheritance, application of the Intestate Succession Act, the scheme of distribution of the estate, administration of the estate, guardians, inheritance rights of parties living in cohabitation, that is parties who are not married to each other, and then the jurisdiction of the courts in resolving disputes that arise from intestate succession. Now, I think that this is, I will only deal with the first 3 or 4 topics in this presentation because of the time. If the women's ministries see it fit, we can complete my outline as I have indicated it here at another stage. The reason is that I think it's no use knowing about the law of succession or intestate succession. Sorry, excuse me. I need to get some instructions. Okay, thank you. So I was saying that because of time, I'm not going to be able to deal with my complete outline. I'll deal with probably up to the scheme of distribution of estates, although this is also quite doubtful. The reason is that there is no point. I want to deal with some of the preliminary issues that are quite important for us to know in order to effectively realize our rights to an estate under this act. I think that is no use knowing about my rights under the act if I cannot actually effectively protect those rights by taking the right procedures or knowing the right concepts, understanding the right concepts relating to the estate. So because of that, I'm going to be looking at some of the preliminary points or issues that you need to understand in order to be able to effectively protect your rights. Because I think this is the purpose of this presentation is a practical protection of our rights. So the key concepts are mainly contained in the Act itself. We will refer to them as we go through this presentation. The key terms that you need to understand are what is an estate. Now, this means all assets and liabilities of a deceased person. Assets may be in the form of immovable property, that is land or the buildings that are on the land, or personal movable property, such as furniture, clothing, goods, or chattels. Now, an estate also includes assets and liabilities which accrue to the person by virtue of his or her death. And it also, now here I'm not quite sure, but I think it includes some of the schemes, for example, the benefits that one gets from insurance schemes and some employment schemes. I'm not quite sure of that. Perhaps we can look it up at a later presentation. Intestate succession is the order of distribution of the deceased estate among his or her heirs in the absence of a will. What this means is that when a person has not made a will, their property will be distributed in accordance with the Intestate Succession Act. And even where they have made a will, if there is a property that they leave out of the will, that property will also be considered as an intestate estate. So an intestate person is a person who dies without having made a will, and includes a person who leaves a will but has personal or real property that he has excluded from the will. So that property becomes part of the intestate estates. An heir or heir-in-law is a person who benefits or inherits from the person who dies intestate. And then I use the term legal system in order to indicate just the totality of all the laws in our country, that is Zambia, including the laws of succession and inheritance and institutions that are created by these laws. Administrator means a person who the court has given permission to manage, if you like, or administer and distribute the estate of the deceased person. A brother or sister under this act okay, sorry about that, there was a small technical hitch. So when we talk about a brother or a sister in intestate succession, we also mean a half brother or half sister and a brother or sister by adoption. It's not just, the immediate brother or sister. Child means a person who is born in marriage and out of marriage. So the act does not discriminate between children who are born in marriage and extramarital children, but it also includes a child who is already conceived at the time of the death of the intestate person, but is not yet born. If that child is born alive, it's included in intestate succession. And then we have the use of the term common property in relation to polygamous marriages. Some people, of course, are married polygamously, and the act also includes polygamous marriages in the distribution of these estates. This common property means all personal chattels of a deceased person which were used in common by him, his wives, and children of every household, that is every polygamous household which the deceased was connected to which the deceased was connected by his marriage, which property is not household property. And then dependent is given a very broad definition in relation to a deceased estate, means the person immediately prior to his death, and who was a person living with the deceased. I'm sorry, I lost my screen. Okay, so talking about a dependent is a person who was maintained by the deceased person immediately before his death, his or her death, and then a person who has been living with a deceased person, or a minor whose education was being provided for by that deceased person, and who is incapable of maintaining himself or herself. A homestead property in relation again to a polygamous marriage means all personal assets of the deceased used by him and his wife and children in that particular marriage. Then the issue just means children, when any person or children, grandchildren, other remote descendants of that person, and the marriage, as I have said, includes a polygamous marriage. A minor means a person who has not attained the age of 18. And then a near relative, when the act provides for inheritance by a near relative, it means children, brother, sister, grandparents, or other remote descendants of the deceased. A parent includes, again, is a very broad definition, includes a guardian who has been responsible for the welfare and education of the deceased person. I'm sorry, I hope my viewers are seeing my screen because are they seeing? Okay, but where am I on the screen? Okay, I'm told to just continue, so I hope I'm moving with all of you on the screen. Now, I'm going to look at the purpose of the law of succession. You know, having looked at those critical terms of the intestate succession law, I want to look at the purpose of the law of succession and inheritance. In simple terms, the law governing succession and inheritance serves the following purposes. Is that screen showing? The purpose of the law of succession. Can you see it on the screen? Okay, I'm instructed to just continue, I suppose, without this screen. So I'm going to leave the screen out and present from my other source. So the purpose of the law of succession is to identify the person who will administer the estate of the deceased person and to define the rules and procedures that person must follow in doing his job. Number two, to identify the estate of the deceased person. What did the estate of the deceased person consist of? The assets and liabilities are included in this. And then number three, to discharge the liabilities of the estate, to pay off the liabilities of the estate. Number four, to determine how the net estate after the payment of the liabilities will be distributed among the heirs of the deceased person. And then number five, to define the circumstances in which a person is not entitled, though entitled to inherit, may be excluded from inheriting in a particular estate. Number six is the deceased to ensure that the deceased's minor children, if he or his minor children, are taken care of, or their estates are taken care of in the distribution of the estate. Okay. Next, I want to look at a very important preliminary issue concerning the application of the Intestate Succession Act, which is a very important preliminary issue. It's important to know to what estate this act applies. So this is the question we want to look at. And the answer to this question is very important, but it's also a major area of confusion in the law of succession. The confusion arises from the fact that Zambia has a dual legal system, which consists of what we call the received law, such as legislation and the decisions of the courts on one hand, and the customary laws of the 73 ethnic groups or tribes that we have in Zambia on the other hand. Now, some people are confused or not sure about when the Intestate Succession Act, or whether the Intestate Succession Act or the customary laws of the 73 ethnic groups apply to the estate they are dealing with. That's the one challenge in the practical application of the Act. Section 2 of the Interstate Succession Act seeks to answer this question. So this act says that the Interstate Succession Act, this section, says the Interstate Succession Act applies to a person, and this is very critical, to a person who was domiciled in Zambia at the time of death. And number 2, who was a member of a community to which customary law would have applied if the act did not come into effect. We need to take a good look at these two ideas, that is the domicile of the deceased person, the concept of domicile, and then who is a member of a person to whom customary law would have applied if the act did not come into operation. The legal concept will start with domicile, the concept of domicile. The legal concept of domicile is complicated, but I've tried to simplify it because it's absolutely important for us to know when the act should apply to a given estate. This concept simply means a permanent home which the law considers every person to have. And this home is used as a test which connects a person, I'll use you in this case, which connects you to the legal system of Zambia. Remember, I defined the legal system, or the system of another country for the purposes of regulation of your intestate succession estate. It's very important also in the area of marriage. For example, a court will not hear a case of divorce, for example, if the person is not either resident in the country or domiciled in the country. So this concept connects you to a legal system, which then regulates your intestate succession. The concept of domicile must, however, be distinguished from citizenship. In other words, you can be a citizen of Zambia, but not domiciled in Zambia at the time that you die. Or you can be domiciled in another country, even though you are a citizen of Zambia. It's also different from residence. Even though residence is a requirement, one of the requirements for acquiring domicile, it's not the same as domicile. We'll see this a little later in the next few minutes. So if this concept of domicile is so important, how does a person acquire his or her domicile in Zambia? Or in another country for that matter? The point or the principle is that each country in the world has its own rules on how you acquire a domicile in that country. In Zambia, every person acquires what is known as a domicile of origin at the time of birth. So you do not, it's an automatic operation of the law. You do not have to do anything. All you need to do is to be born in Zambia, and voila, you have a domicile of origin. The domicile of origin attaches to a person and remains so attached wherever he or she goes, unless and until he or she changes for another domicile. Then the new domicile to which they have changed also attaches to that person until they have changed that domicile. The point is that at every point in your life, you must have a domicile in legal terms. You must have a permanent home that connects you to the legal system of Zambia. So you cannot simply abandon a domicile of origin. You have to change to another domicile that attaches to you subsequently. So domicile of origin, how do we, what are the different categories or the domicile of different categories of people in Zambia? And this is what we want to look at next. I'm sorry, I'm not sharing the screen, but this is the next question that we want to look at. The domicile of origin of a legitimate child, that is a child who is born in marriage, is the domicile of the father if he is alive at the time of birth of the child. Similarly, a posthumous child, that is a child who is born after the death of both parents, for example, where both parents perish in an accident and the mother is delivered of the baby after she is born through a cesarean section, the domicile of that child, domicile of origin, is the domicile of the mother at the time of birth. Thirdly, an extramarital child, a child that is born outside of marriage, takes the domicile of the mother at the time of birth. If the extramarital child is legitimated according to the laws of Zambia, in other words, they cease to be extramarital. I don't want to use the term illegitimate because that is not a very friendly term used in legal terms anymore. So if a child is legitimated, becomes a legitimate child, he or she takes the domicile of the father, not of the mother anymore. A foundling, that is a child whose parents are unknown. We know in Zambia of several instances where a child found in a bin or in a toilet abandoned. The domicile of that person or that child is the original domicile is the domicile of the place where the child is found. So in this case, it would be in Zambia if the child is found in Zambia. Now, this is a critical one. I'm sure you'll all be interested. A woman acquires, interested for different reasons, a woman acquires the domicile of her husband on marriage, and her domicile follows the domicile of the husband throughout the marriage. So whenever the domicile of the husband changes, her domicile also changes automatically. And I think you can already begin to see the problem there. And this applies whether the parties or the spouses are separated by a judicial order. So you can be living apart, but each time your husband changes their domicile, you also change your domicile automatically. Simple example, a husband is before judicial operation, a husband is domiciled in Zambia, which is important for purposes of applying the Interstate Succession Act. And then the husband, out of spite, decides to move to the UK. And his wife, who is left in Zambia, has his domicile in the UK. Okay, which obviously means that if problems arise, disputes arise, the court here will not be able to hear her application for intestate succession until she brings back her husband to, to a domicile in Zambia, when she can then institute proceedings for intestate succession. So that is one major issue about the domicile of a married woman. But her capacity to exercise her choice to have a domicile of her own revives upon the dissolution of the marriage, whether by death or by divorce. If, however, she does not exercise this choice, she continues to run with the domicile of her husband and follows it when and if he changes it. Okay, so I have talked about the domicile of choice, that you can change your domicile of origin by adopting a domicile of choice. How is this domicile of choice acquired? Again, this is better understood if we just look at the way different categories of people or family members acquire a domicile of choice. In the first instance, any person other than a minor who is aged 18 years, as we have already seen, or a person of unsound mind, or a married woman may at any time change his or her domicile of origin. In other words, apart from these categories, that is a minor, a person of unsound mind, and a married woman can change their domicile of origin or domicile of dependence by choice. So a minor can change his or her domicile of origin when he or she reaches the age of majority. Otherwise, his or her domicile changes according to the parents' domicile, because the minor has no capacity to acquire a domicile of his or her own. But when this domicile of a minor, the original domicile changes, it's no longer called a domicile of origin. It's called a domicile of dependence, because the minor is depending on the domicile of the mother or the father that may have changed. And as I said, a married woman may change her dependent domicile if she is divorced or the marriage is terminated by death. So what is required for you to prove the domicile of, that you have a domicile of choice? We now leave the domicile of dependence or domicile of origin. You want to acquire a domicile of choice. What does the law require you to have in order, or to prove in order to show that you have acquired a domicile of choice in Zambia? The first element, there are two elements here. The first element is what is called factum residence. Again, I wish I could share my screen because you would need to see how that is written. But anyway, all that this means is that you must take residence in Zambia if you are domiciled in another country. So if you are domiciled in the UK, for example, you must take your residence in this country. The length of the duration of the period does not matter. It can be 3 days or 4 days, and if you die, for example, in that period, but you have acquired a domicile of choice, your estate will be administered under the Interstate Succession Act. So what matters is that you are personally in Zambia, resident in Zambia. Then second requirement is called animus manendi. This is a Latin term, but all that it means is that you should form a fixed and settled purpose in your mind for making Zambia your principal or sole permanent home during the period of your residence in this country. So you must not have a deliberate intention where you think, I'll change my, my domicile, or I will change my residence in Zambia. Let me give this example. You come to Zambia from another domicile in order to look for a husband or a wife in the Seventh-day Adventist church, okay? And in your mind, that is your purpose for coming to this country. So you have already determined ahead of time that your residence is going to last just as long as you are looking for that hubby or for that wife. The moment you get that hubby or wife, you leave the country. You cannot satisfy the requirement of intention and the factual presence, your factual presence in this country. Okay, so that's what animus manendi means. Okay, in my screen, I wish you could see it. I have a heading saying, mission accomplished. Once it can be shown that the deceased had a domicile of origin, or a domicile of choice, or a domicile of dependence in Zambia, then the Intestate Succession Act as requirement of those two requirements, one of them is met. That is the requirement of domicile. This condition of domicile or requirement is particularly important for estates of Zambians, administration of estates of Zambian citizens who have gone to work overseas and they die while they are working overseas. And I have had a number of inquiries from Zambians over the period that I've been working in this area, who find themselves in those positions where a spouse, for example, who went to work overseas dies while they are there. And the issue, they have acquired property there, they have property here. The issue is raised whether the Intestate Succession Act will apply to that person. So this issue of domicile is particularly relevant for those kinds of situations, because you will be able to determine or to say, to prove, if you are able to prove that although the person has been working in the UK, for example, in England for 20 years, they actually never changed their domicile, their Zambian domicile of choice, dependence, or origin. Then that estate will be administered according to the intestate succession, provided, and this is a very important limitation as well of the act or challenge, provided that there are no conflicts between the Zambian law of succession, which is the Intestate Succession Act and what it provides, and the law of the country where that person is currently, or where that person dies. The conflict might be that in that country, for example, the law requires that the estate, the immovable property of that person is administered according to the law of that country. Whereas in Zambia, the Intestate Succession Act is saying, as long as you are domiciled in Zambia, you are, your estate, immovable property as well can be administered under the Intestate Succession Act. So that is the problem of what we call conflict of laws. And that subject is for another day, Women's Ministries, because it's absolutely important. In a globalized world, our children, our husbands die anywhere in the world, and we want to know whether the Intestate Succession Act or the law of Zambia or the law of another country will regulate their property, the distribution of their property. But otherwise, for Zambians who have never traveled or who have never left the country, the issue of domicile does not really arise, because the law, assumes that this person is permanently resident here. They have never had an intention to leave Zambia and form a domicile of another country. And this is the majority of the people who are affected by the Intestate Succession Act. So then we move on to the second, when should I stop, ma'am? I can continue until 15? Okay, thank you. I'm allowed to continue for another 15 minutes. So we then move to this other second requirement for the act to apply to is an estate in Zambia. And this is what we saw in section 2, which says a person must be a member of a community to which customary law would have applied if the act did not come into operation. Now, this is another problematic area because the categories of persons to whom customary law applied before the act came into force is not clear in the act itself. However, it appears that the act envisages its application generally to Africans of indigenous origin, that is all Zambians, of course, Black Zambians, if you like, and historically, they have the identity of an African who is governed by some customary law. All of us belong to some some tribe or ethnic group, which has a system of customary law. Tonga, Bemba, whatever, each one of those have their systems of law. So it seems that persons who would be considered as indigenous persons who belong to any of the Zambian ethnic groups are persons who are targeted by the application of this act. And on this interpretation, the act would not apply to people who are not Zambians in this sense that I have defined the term. Then their estate cannot be, let's say it's a British person who has domicile here. They may have a domicile of origin or domicile of choice in this country. But if, in fact, they are not, if they are non-Zambians, they cannot claim to be persons who were regulated by customary law before the act came into force because they have no customary law of the ethnic groups. Of course, the law also provides for a situation where a person may be bound by customary law, even though they are not indigenous people or Black Zambians, if I may just use that term. Again, that belongs to a subject we call internal conflict of laws, and it is for another day, Ministry of Women's Ministries. Now, this position that a non-African person cannot be bound by the act has been adopted by or confirmed by the High Court in a case where it held that the act did not apply to a British and that his estate could not be administered under the Intestate Succession Act. So Indians as well may not apply this act to administer their estates. Okay. Now, what law then will apply to these people who have no, to whom the Intestate Succession Act does not apply? Strangely, the law of England, which was in force on the date of 17th August 1911, would be the law that applies to these people. You can see how old the law is. It has not changed according to the times, but that's what would apply to these people who are non-African Zambians. Okay, let me move in my few minutes left to another heading, which I say mission accomplished in my shared, what would have been a shared presentation. Once it's shown that the deceased person belonged to a community to which customary law applied, the two requirements for application of the Intestate Succession Act have been met. That is domicile and this last requirement that we have looked at. But the Act also makes further exceptions of property, types of property that may not be administered according to the ISA. And please, this is very important because there's no point for you going to court, expending a lot of money trying to administer an estate under the Intestate Succession Act, which does not fall to be administered under this Act. The three exceptions are property, that is land which is at the time of death of the intestate was had not, so the land that was held under customary law. A lot of us these days acquire land in traditional leaders' areas. That land will not be governed by the Intestate Succession Act if it was acquired as it is usually according to the customary laws of the particular traditional ethnic groups. And I know a lot of women who own property in these areas. Of course, unless you have acquired a tenancy where the government or the council has given you title in that land for 14 years or whatever period, then that act is no longer regulated or acquired, that land no longer regulated or acquired according to customary law. The next type of property is what the act calls institutionalized property of a chieftainship. Chiefs have some kind of property that belong to that institution alone. And you can, maybe it's a gun or whatever it is that belongs as a matter of customary law, or what is it, the whisks, which traditional leaders use. You want to look cool by bringing that whisk and seeking to inherit it from a traditional chief so that you can be fanning yourself with, in the heat. You cannot inherit that property because it's a simple example. You cannot inherit it because it's part of a chieftainship's property. And the last one is what the act calls family property. This is property that has been acquired by family members for the family. You cannot intrude in that property and seek to apply the Intestate Succession Act to distribute the property of the deceased. Okay, then I must say that this Intestate Succession Act finally on these issues of what estate can be administered under the Intestate Succession Act. I should say that in addition to these three, apart from these three properties, all the ethnic group customary laws have been abolished by the Intestate Succession Act. And this is good news because a lot of abuse of, women's rights, children's rights in intestate succession were allegedly carried out under customary law, most of which was distorted customary law carried from the colonial period, which is not part of the customary laws of, evolving part of the customary laws of the ethnic groups. But this is good news because the customary laws no longer, of the 73 ethnic groups, no longer apply to the administration and distribution of a deceased person's property or estate, except for these three exceptions that I have mentioned. The next topic would have been the distribution of the estate to the heirs under the Intestate Succession Act. It's a huge act which I cannot finish even if I were given another 20 minutes. I'm sorry, we have to stop here. But if Women's Ministries sees it fit, they can organize another presentation on this topic together with the remaining topics in my course outline. I thank you all for listening to me. I'm so sorry that I was not able to share these complex concepts on the screen with you, but maybe I hope that you have picked up something. Thank you so much.
Oh, we can allow, I can see a hand from Tendai. Please, can you speak?
Good afternoon. Thank you so much for the presentation. We really appreciate it. My question is, what recourse does a beneficiary of an estate have in a situation where the estate was administered when they were a minor, but to their detriment, bearing in mind the statute of limitations.
Okay. So, unfortunately, at the time that the beneficiary is a minor, the decisions are taken by their legal guardian. So if the guardian makes wrong choices or mistakes, okay. So the question was, what recourse does a minor have if the estate was distributed when the beneficiary was a minor, and they are now, they've attained the age of majority? Unfortunately,
Yes.
the law recognizes that the decisions are taken on behalf of the minor by the legal guardian. And I have come across a number of such situations where, for instance, the parent, maybe the spouse of the deceased, disposes of properties before the minor attains the age of majority. The recourse is to the guardian, the legal guardian, and not the administrator of the estate. Unfortunately, that is the situation.
Thank you.
There was a question in the chat about what happens if the parties to the intestate estate and this distribution, if the parties are separated. As long as the separation is not a divorce, the parties, the spouses must inherit from each other in terms of the Intestate Succession Act, according to the rules for distribution of the estate. And these are the rules that we'll look at in the next presentation if we have a chance to do so.
There's another question on the chat. It says, can one spouse write a will on their own? Yes, I did touch on this. A spouses cannot write a will jointly. Okay, spouses cannot write a will jointly. One spouse writes a will on their own relating to their property, and the other party, the other spouse can write a will relating to property that they own. Now, I've come across this situation several times. One spouse buys a piece of land, which is in his or her name. The other spouse contributes by providing resources, and they build the house. At the point of death, the spouse who contributed or who dies, the title is in his name, the spouse who contributed will get a portion of that. Now, if the deceased has other children outside that home, you see how unfair it is. The other children benefit from that house, but the resources came from the other spouse who is still alive. So it's a situation that I encourage spouses to deal with from a different angle. Where you contribute resources to a property, try and make sure that your name is included on a title by deed of moet. Okay, there's another question. If the wife dies, the husband remarries, does she benefit what was acquired by the... If the wife dies, okay, so a situation where a spouse dies and the husband remarries, does the other woman benefit from that property? Indeed, she does. She does, because if it's in the name of the husband and she is the spouse at the time that he dies, she benefits. I've come across, I encourage people to write wills because I've come across this situation. This lady buys a piece of land, builds a house. When she dies, the property belongs to her husband and the children. He remarries. The new madam does not get along with the children and chases all of them. Then he dies and she becomes the widow who is living at the property. who has a superior interest from the children who don't live there, because they cannot come and say, get out of our house, we sell. So it does happen. When you are a widow, it doesn't matter where the house came from. If it is in his name, you will benefit.
But I think the Act also provides for some protection to the estate by stating that, or requiring that the court or the administration of the estate takes into account the duration of the marriage of the second wife, for example. In other words, if a wife is married and within 2 days of that marriage, the husband dies, but as my panel mate has indicated, that property was acquired by the previous wife with their children, the court will take into account the period for which that person has been married in determining what they are entitled under, at least under intestate succession. So the Act has some kind of mitigation for that kind of situation. But we'll look at that the next time we have time to discuss the rules of inheritance.
What happens if the couple was married under the marriage, it says marriage law, but I believe it's under the Marriage Act. So the position in Zambia is that living together is not a marriage. No amount of cohabitation can convert it into a marriage. If parties are living together, they must be married under the custom, under customary law, or under the statute. So in terms of the Intestate Act, it doesn't matter whether you're married under the Marriage Act or under customary law. You still benefit as a spouse.
Okay, when we look at the rules of intestate succession, as the courts have interpreted them, we will actually see that there are cases where the courts have granted a right of inheritance to persons who are not married. That is, persons who are living in cohabitation. But as I said, that's for the future.
Anything else? Perhaps any hands? Okay, so I'll ask Sister Lufungulo to come and close.
There's a hand. You can speak out. Mwaka?
Oh, thank you very much.
Mwaka, you can go ahead.
My question relates to a situation where perhaps as a couple, property, and if, for example, or perhaps the husband has more property, which he has put in his name, and then he has allowed the wife maybe to put 1 or 2 properties in her name. If he dies and leaves all the property to the children, if that wife is not happy with that, can she contest, or do they take into account that she already has some property, and therefore the other property which was shared by their husband or given all to his children will have to take into consideration that aspect? I don't know if I was clear.
I think it was, you tell me if I didn't get it right. So the question is, the husband puts some properties in the wife's name.
Yes.
And when he dies, he gives some properties to his children and whether she can challenge. So section 20 of the Wills and the Administration of Tested Estates Act provides the mechanism through which a will can be challenged. That's in section 20. So you would have to show that you will suffer hardship because of that bequeath or because you have been excluded. But the challenge there will be that he'll be able to explain that this one, during her lifetime, I was able to do this and that for her. And that is the reason why I have excluded her from the will. So in the event that perhaps the wife contributed and whatever, it is important that you assert your rights during the lifetime of that person. It happens more often than not that perhaps a wife invests in this relationship by placing properties in the names of the husband. Unfortunately, if the property is in his name and he writes a will and gives the property to third parties, it's an uphill battle to challenge unless you can show that you will suffer financial hardship.
And in the law, in the law of intestate succession, remember that we are administering the estate of a deceased person. So if in fact during the life of the spouses, property has been, the husband's property has been registered or given to, to the wife, and she holds the title to that property. That property is no longer the deceased husband's property. So the issue of limitation on the inheritance by the wife should not arise. But as my colleague has said here, even in the area of intestate succession, if a person or a beneficiary under the estate can show that they are suffering grave hardship because of the way that the rules of intestate succession have benefited the other spouse to the exclusion of that other person, they can bring a matter to the court for redress. And when we look at these rules of intestate succession, I'll be able to give you some of the cases that the courts have decided on this issue. Thank you.
Okay, so I can see Felicitas. Felicitas, you can ask your question.
Thank you very much. My question is a build-up on the question that was earlier, I think the part that was earlier handled, where you said that when you have a deed of moyet on a property joint with your spouse, I wanted to know if one spouse dies, in this instance, okay, a man, and then there are children outside marriage. I think you had touched on it, but I don't think I got it clear. What happens where you have a deed of moyet on that property, then there are children outside that marriage?
Okay, so if he dies intestate, what will happen is that in land law we have what is called the right of survivorship. If you hold the property jointly with another person and that other person dies, the one who has survived will get title to that land or property. So when you have a deed of moyet and there are two people on that title, unfortunately the others are excluded. Is it a hand or on the chat? If there's a hand, please, you can ask. iPhone K, you can ask your question.
Hello.
Hello.
So my question is, in a situation that I leave a will stating that all my property goes to my husband, is it possible for me to state that if he gets remarried, the property is to be transferred to my children instead?
It is a common provision. It is a common provision, but I've never seen the court interpret Section 3 of the trust restriction in relation to that particular issue. But it is a very common clause in wills that if the spouse remarries, they lose their benefit on the will. So I saw there are a few more questions. What's the benefit of a trust versus a will? So in a trust, my thoughts really between the two is that operatively they are the same, but I would prefer a trust. Why? In my lifetime as a lawyer, I've seen too many cases where the court sets aside a will. It shouldn't be the case, but I've seen it happen. But when you register a trust, the trust is registered long before you die. And the trust will state that in the event of my death, I would like so and so to benefit. So I would place my weight more on a trust rather than a will. And I've stated the reason why. I've seen something like share your contact. Please get in touch with the women's ministries. The Law Association of Zambia will land on me like a ton of blocks if I dared to do that. So please get in touch with the women's ministries, then they can get in touch. What happens when the will is considered invalid on a technicality? Okay, the question here is that the deceased signs a will on a different date from the witnesses. Definitely that is it's invalid. The rules are very clear. The will must be signed at the foot by the testator in the presence of the two witnesses who must sign at the same time at the direction of the testator. So it is important that people note that the witnesses and the testator must sign at the same time on the same day, same place. They should be in the same place. NAPSA, they will follow the Intestate Act. NAPSA will follow the Intestate Act. Yes, yes. That's all. Okay.
There's one above the NAPSA question. There was a question just concerning moiety. In the chat box.
Okay, so the question says, oh, it's an intested question. Maybe my colleague can deal with it, but it says, when one contributes to say NAPSA, where there's no written will, is it right for any listed person to be removed from benefiting? I don't think so. As long as you are a child of the deceased, spouse of the deceased, you are covered within the categories, you benefit according to the Intestate Act.
I think that's the position. As I said, I still need to study those particular acts. But if you look at the definition of an estate, it includes anything, as I said, that accrues to the deceased as by virtue of their death. And so those NAPSA beneficiaries obviously accrue by virtue of death. And as my colleague has said, there is no basis on which a person can be removed from that which has become part of the intestate succession estate.
No, it's a comment. I think that's your phone number. So maybe the takeaway points, if I were to summarize my presentation and just give my takeaway points, it's very important that you leave in place an arrangement or arrangements for your children, for your spouse, for your family, by way of a will, or like Sister Lubu has stated, by way of a trust. Because you have no guarantee of what will happen to your children when you're not there. Maybe the one who will come, maybe even your spouse will come and say, this child cannot remain at Chengero, we don't have money. Can he come to Chakuti Primary School? So I would encourage everybody, please write your wills. You will not die simply because you have written a will. Thank you.
For me, I think the point, the takeaway point is the preliminary issues that I looked at are, as I said, quite critical. You will not be able to realize your rights of inheritance under the Intestate Succession Act if, for example, you do not understand how you can efficiently claim those rights. And the important point about this is that if you are not aware, for example, whether the Intestate Succession Act applies to your spouse, and you are still looking around, running for my colleague's services, which are quite expensive, by the way. By the time you actually come to discover that this person was actually domiciled in Zambia and I can help claim the rights under the Intestate Succession Act, your competitors in that estate have gone ahead of you and done the administration of the estate. And this I have seen a lot of cases in my research over the past 20, 30 years in this area, where women wake up to the rude shock where the estate that they are entitled to and they should have actually claimed has been long administered or long grabbed, by the way, you know, where the estate has been administered under customary law, which, as I said in the earlier part of my presentation, no longer applies to administration of estates. On the ground, people are busy, and unfortunately some courts, particularly the lower courts, issue letters of administration or orders of administration for those estates. And so you lose out by not really grasping those preliminary issues that you need to know whether this act can help me to claim rights. And, you know, if you know these things, for example, you may not need to go to my expensive colleague. I'm not demarketing her. You can take your case to the local courts and, you know, be able to present some of these cases where the estate, of course, falls within the limits of the jurisdiction of that court or the subordinate court. So that's my takeaway. Don't ignore, don't just run and jump to what your rights are under the legislation, because you will lose out if you do not know some of these the preliminary practical steps you need to understand. Thank you.
Thank you very much. We are very thankful for your time. I know we have taken a lot of time due to, you know, some issues that we are going through with the clinical, but we are very happy and we are thankful that you had all the time to listen. We have taken note of the remaining programs. Indeed, we shall look into that, and very soon we shall call for another presentation. If you are carrying any questions, you may jot them down and you can forward them to my number, which I've seen it has been shared on the screen. And if any queries, please share them with me, and then we'll take note of that. As we close, I'll ask Sister Kabalata just to come and close in prayer.
Shall we pray? Our gracious, kind, and loving Father, we thank you, Lord, that you made it possible for us to gather in this manner. As we part one from another, we pray, Lord, that you continue to be with us and that whatever it is that we have learned here will be able to bear fruit. Be with us, Lord, for this is our prayer in Jesus' name with thanksgiving in our hearts. Amen.